Recommendations 94. The Special Rapporteur urges Member States A. To impose sanctions and a full arms embargo on Israel, including all existing agreements and dual-use items such as technology and civilian heavy machinery. B. To suspend or prevent all trade agreements and investment relations and impose sanctions, including asset freezes on entities and individuals involved in activities that may endanger the Palestinians. C. To enforce accountability, ensuring that corporate entities face legal consequences for their involvement in serious violations of international law. 95. The Special Rapporteur urges corporate entities A. To promptly cease all business activities and terminate relationships directly linked with, contributing to, and causing human rights violations and international crimes against Palestinian people in accordance with international corporate responsibility and the law of self-determination. B. To pay reparations to the Palestinian people, including in the form of an apartheid wealth tax along the lines of the post-apartheid South Africa. 96. The Special Rapporteur urges the International Criminal Court and national judiciaries to investigate and prosecute corporate executives and/or corporate entities for their part in the commission of international crimes and laundering of the proceeds from those crimes. 97. The Special Rapporteur urges the United Nations A. To comply with the International Court of Justice Advisory Opinion of 2024. B. To include all entities involved in Israeli unlawful occupation in the OHCHR database to be properly accessible on the OHCHR website. 98. The Special Rapporteur urges trade unions, lawyers, civil society and ordinary citizens to press for boycotts, divestments, sanctions, justice for Palestine, and accountability at the international and domestic levels. Together, the people of the world can end these unspeakable crimes. 99. The present report is written at the cusp of a profound and tumultuous transformation. Globally witnessed atrocities require urgent accountability and justice, which demand diplomatic, economic, and legal action against those who have maintained and profited from an economy of occupation turned genocidal. What comes next depends on everyone. Annex. Overview of the legal framework governing the legal responsibility of corporate entities in the occupied Palestinian territory. 1. Introduction. 1. This annex sets out the international legal framework broadly applicable to the corporate sector implicated in the occupied Palestinian territory, OPT. It aims to provide guidance on the interpretation and application of the legal concepts and factual findings presented in the main report. Not intended as an exhaustive exposition of international law in this domain, it presents the broad principles of corporate responsibility, particularly those applicable where corporate entities are implicated in displacing Palestinians from their land and replacing them with unlawful colonies contrary to international law. Corporate entities risk being held responsible for exploitative, abusive, and even criminal conduct. Although corporate responsibility for and criminal complicity in violations was certainly identifiable in the OPT prior to October 2023, subsequent factual and legal developments could implicate corporations in unlawful occupation and genocide. 2. Corporate responsibility for violations of human rights, international human law, and crimes under international law is governed by legal instruments at the domestic, regional, and international levels. 3. The UN Guiding Principles on Business and Human Rights, UNGPs, constitute the normative framework at the international level for the regulation of corporate conduct with respect to human rights. They set out what states and corporate entities need to do in order to comply with existing obligations under international human rights law and are already having a significant impact on national law and policy. Indeed, the UNGPs provide the normative lens through which corporate conduct can be assessed in order to establish legal relevant facts in litigation where corporate liability is addressed. They are concerned both with preventing adverse human rights impacts and ensuring remedial actions are taken where corporations' conduct causes, contributes, or is directly linked to such impacts. Crucially, heightened normative requirements apply in contexts of conflict, occupation, and structural vulnerability, especially where domestic enforcement of international human rights law may be weak or compromised, rendering international oversight necessary. 4. Other areas of international law establish specific legal obligations for corporations, especially international humanitarian law, which is binding on non-state actors involved in armed conflict, and international criminal law, under which individuals such as corporate executives and increasingly corporate entities themselves can be held criminally liable. Domestic courts are the primary jurisdiction for the enforcement of corporate responsibility for human rights violations and international crimes. 2.1 States as primary duty bearers. 5. International law accords states the primary role of ensuring that corporate entities don't violate international law and respect human rights as part of their obligation to respect, protect, and fulfill human rights. Under international human rights law, confirmed by the UNGPs, states may be found in breach of their human rights obligations where they fail to take appropriate steps to prevent, investigate, punish, or address abuses by private actors when human rights violations occur. States have an obligation to extend this regulation and oversight to the operations of corporations that occur outside their territory in accordance with general extraterritorial human rights obligations. 6. Furthermore, under the rules on state responsibility, violations of human rights by private actors will be attributed to a state where a corporate entity acts on instructions from or under the control or direction of the state, is empowered by state legislation to exercise elements of governmental authority, or where the state acknowledges and adopts the conduct as its own. Accordingly, the UNGPs require states to take additional steps to protect against human rights abused by corporate entities owned, controlled, or receiving substantial support from the state. 2.2 Responsibilities of corporate entities. 7. The UNGPs apply to all corporate enterprises, regardless of their size, sector, operational context, ownership, and structure. The responsibility of corporate entities for human rights violations and crimes under the international law exists independently from that of states and irrespective of the action states do or don't take to ensure they respect human rights. Consequently, corporations must respect human rights even if a state where they operate does not, and they may be held accountable even if they have complied with the domestic laws where they operate. In other words, compliance with domestic laws does not preclude, is not a defense to responsibility or liability. 8. Corporate entities are obliged both to avoid violating human rights law and to address human rights violations resulting from their own activities or their business relationships with others. To achieve this, the UNGPs establish a continuum of involvement and associated responsibilities. These reflect the complexity of corporate structures and economic value chains, and the fact that the nature of a company's involvement in a particular human rights impact may shift over time, so that if it doesn't take appropriate action, it could move up the continuum. The activities of a corporate entity and its relationships can be seen as part of an ecosystem which may altogether, by perpetrating, facilitating, enabling, or profiting, adversely impact human rights, resulting in violations. A corporate entity's responsibility depends primarily on whether its activities or relationships throughout its supply value chain risk or are, in fact, A. causing human rights violations due to its own activities being essential to the human rights abuse being able to occur, B. contributing to violations through its own activities, either directly or through some outside entity, government, business, or other. This includes any activity or relationship where a causal link can be established between the corporate entity's actions and the resulting violation. Causality between the entity's actions and the resulting abuse will be considered to exist where it has facilitated or enabled the abuse, created strong incentives for a third party to breach international human rights law, or undertaking activities in parallel with the third party, leading to cumulative impacts. C. Directly linked to violations through its operations, products, services, or corporate relationships, although it need not itself be contributing to the abuses. 10. The UNGPs expect corporate entities to ensure that they are not implicated in human rights violations by undertaking periodic human rights due diligence, HRDD, to identify concerns and adjust their conduct. Additionally, in situations of armed conflict, occupation, and other instances of widespread violence, corporate entities are expected to engage in heightened human rights due diligence throughout the period of the conflict. 11. As part of this heightened process, which is imperative in the OPT, corporate entities should ask themselves 3 questions regarding their actions and omissions. A. Is there an actual or potential adverse impact on human rights, or is the conflict connected either to the corporate entity's activities, products, or services? B. If so, do the corporate entity's activities increase the risk of this impact? C. If so, would the corporate entity's activities in and of themselves be sufficient to result in that impact? 12. In answering these questions, corporate entities must consider conflict will always create adverse negative human rights impacts. Therefore, a corporate entity operating in a conflict will always cause, contribute to, or be directly linked with human rights impacts. Corporate activities in a conflict-affected area can never be neutral. Even where a corporate entity does not take sides in a conflict, its activities will inevitably affect the conflict dynamics. Corporate entities need to respect standards of international humanitarian law and the obligation to prevent genocide in addition to human rights. 13. Based on the above assessment, a corporate entity has particular legal responsibility. A. Where it causes human rights violations, answers yes to all 3 questions, it has a responsibility to cease the action and to provide remedies and reparations for harm caused. B. Where it contributes to human rights violations, answers yes to questions 1 and 2, no to 3. It has a responsibility to take the necessary steps to cease or prevent its own contribution to human rights violations, including terminating relationships, to mitigate any remaining impact through its leverage, and to cooperate in the remediation of the harm. C. Where it is directly linked to human rights violations, answers yes only to question 1. It is required to use its leverage, including collaboratively, to prevent or mitigate the impact on human rights. Should that leverage prove ineffective, it must consider terminating relationships. Failure to disengage from a high-risk context, despite due diligence, will increase a corporate entity's liability for the violation.